Good morning, good afternoon, and good evening. Welcome to all, and thanks so much for joining this webinar on early abortion bans. My name is Nina Sun, and I am the Deputy Director of Global Health and Human Rights at Drexel University School of Public Health. And I'm also an Associate Editor for Sexual and Reproductive Health Matters. So for those of you who are less familiar with SRHM, at the heart of our work is a multidisciplinary open access peer-reviewed journal that explores emerging strategic and neglected issues across the field of sexual and reproductive health and rights. But SRHM is more than just a journal. It also creates and participates in spaces that motivates for improvements in research, policy, services, and practices. It contributes to capacity building and knowledge generation and inspires new rights-based thinking and action across the field of sexual and reproductive health and rights. And that includes by working very closely with partners at the global and local level. So before we dive into the substance of the webinar discussion today, I wanted to pass the floor over to my colleague, Jessica, who will give some administrative logistics of how the webinar will work.
Thank you, Nina, and thank you everybody who has joined us so far. During the webinar, we will be collecting questions using the chat function. So you should be able to see that at the bottom of your screen. So feel free to post your questions throughout the webinar and we will address them towards the end in a question and answer session. We won't be using the raise hand function, so please just direct your questions to the chat. We also invite you to join the conversation on Twitter, tagging SRHM Journal and using the Stop the Bans hashtag. Thanks, Nina.
Thanks very much, Jessica. So today's webinar, as I've mentioned earlier, will focus on a discussion looking at early abortion bans in the United States and abroad. So we're going to look at a new wave of anti-abortion strategies and tactics. And joining us today, we have 5 incredible panelists. So first, we have Dabney Evans, who's an associate professor at the Hubert Department of Global Health at Emory University. Dabney is a mixed methods researcher and professor of issues affecting vulnerable populations. We're also joined by Suba Narasimhan, a postdoctoral fellow also at Emory, whose research focuses on epidemiology, reproductive health, global health, policy analysis, and capacity building. We also have Megan Gordon-Kane, who's the public affairs coordinator of the Feminist Women's Health Center. That's a service provider in the US state of Georgia and also engages in community education, grassroots organization, public affairs, and advocacy programs. We will then turn to Nimra Chowdhry, the State Legislative Counsel for the Center for Reproductive Rights, who's responsible for tracking and analyzing the range of state legislation and regulations affecting reproductive health in the United States. And finally, we turn to the global perspective from Gina Dillon, who's the Associate Director of Health Access at IPAS. So turning to our first speakers, Dabney and Suba, your recently released article in which you conducted a narrative analysis of anti-abortion testimony and legislative debate has gotten a lot of attention since it has been released. Could you tell us a bit more about your research and findings and what inspired you to conduct this type of research?
Absolutely. Good morning, Nina. Thank you for the introduction. So I'm going to begin presenting on behalf of my co-collaborator Dabney and myself. And we will be talking about our narrative analysis of anti-abortion testimony and legislative debate, which focused on HB 481, also known as the fetal heartbeat abortion ban. And just a kind of caveat, we will be using the term heartbeat because it's used throughout the legislative debate. That is not our terminology for the biological process in the ban. Our narrative analysis focused on Georgia, which is in the southern United States. It's a state that's well known for having challenges around abortion access and maternal mortality, and just generally around health services. So how we began this analysis is that both Dabney and I are residents of Georgia, and we actually attended the legislative debates in March of 2019 when they were debating the early abortion ban. And during that time, we realized there was sort of a gap in the knowledge. Public health as a whole often examines the outcomes of policy. And there are many methods to look at the end result of policy. However, the legislative process and what arguments and evidence are used in the legislative process is often overlooked. And that was the impetus for us doing this work. Sorry, 1 second, we're gonna switch the slide. So the study purpose really here was to understand the anti-abortion rhetoric and also the evidence that was used in the HB 481 legislative debate and also the community testimony. Because if you're unfamiliar with the process of how a bill becomes law, it passes through committees, and within those committees, community members are also allowed to testify on behalf of either support or opposition to a bill. So as we attended the committee meetings, we essentially decided that we would then look for this narrative analysis, which is publicly available online. So in the Georgia legislature publishes video archives of these committee meetings. So we looked for the publicly available data from committee meetings in March of 2019. And then we actually transcribed them from their video form into just an audio form, then moved into a transcript form, and then coded them in using a qualitative methodology. So, yeah. So what we really found, the crux of our work and the crux of the article, is that we found that there was both a what and a how of the information in the legislative debate. So the what really focuses on the tactics that were being used in the rhetoric, and the how what is really about how what the rhetoric meant in the larger context, what divisions or lines were being drawn. So the what included things like the use of heartbeat, quote unquote, as a marker of life, this need to create a new protected class of persons, an argument to expand state sovereignty and therefore protect fetal rights. And overall, the goal was to pass this legislation out of committee and into law, which the governor did sign in, I believe, May of 2019, and also to challenge Roe v. Wade at the federal level. The how is somewhat of the interesting part in a lot of ways. So what they often did was use significant appropriation, and my colleague Dabney is going to dive directly into all of these pieces and kind of more fully give you a picture of what was happening in the debate. There was also an oversimplification or kind of a flattening of very important scientific concepts. And I think that's been documented a lot in media and public scholarship. There was also a layering of the debate, this fetal rights argument onto that of women's health. And what was also interesting, and I think a very novel finding within Georgia, was that there was a large capitalization on progressive gains. And to do that, they often used false equivalencies between fetuses and the plights of vulnerable populations in the United States, populations that have been historically marginalized, including Black people and LGBTQIA people. And now I'm actually going to turn it over to Dabney, and she's going to dig deeper into the results.
Thanks, Suba. So as Suba mentioned, our paper is focused on the strategy and the tactics and not necessarily the particular words we used in narrative analysis, but I do want to warn that the next couple of slides are going to include some direct text. And again, sort of the participants in our study are legislators who are debating the bill, as well as community members who are testifying. And these are, our focus was only on supporters of HB 481. So we call those folks anti-abortion advocates or proponents or supporters of HB 481. So I'm going to spend just a little bit of time breaking down the three elements of the what that are mentioned here on this slide, and then another slide and a table discussing the how. So again, the strategy and the tactics. And this is really a scaffolded argument. So the first element that we found in our research was the use of heartbeat. And again, we use heartbeat in quotes because this is not our preferred language. But the attempt here was to establish a legally significant and medically sound indicator of life. And some examples were given here, particularly references to things like a flat line, something that everybody has seen on an episode of a medical show or a movie. And that being the absence of a heartbeat is death. And so therefore the reverse of that must be life. So connecting the dots between the ability to detect fetal cardiac activity and the idea of life, and then connecting life to the idea of personhood, which is an important term and serves a special meaning within the legal field in terms of protected classes, which is the next element. So just a few quotes here from some of the participants, or what we derived from our verbatim transcriptions of the committee hearings. Another element of this piece of the argument had to do with what we call lexical bridges, terms like unborn child, child in utero, and early infant, which are not medical terms. So the medical definition, for example, of infant is from birth until age 1. So there is actually no such thing as an early infant, but using terms like this, they sort of anthropomorphize, or they bring to mind certain imagery, and this is part of the tactic that's used to further this argument. So the second element that we examined, as Suba previously mentioned, was the idea of legal protection for fetuses, and really trying to make the claim that fetuses should be a protected class, similar to other protected classes like those that Suba has mentioned, and in particular enslaved Africans and LGBTQ people who have fought for their civil rights in this country successfully. And that's probably one of the most important findings from our paper, is the way in which these progressive legal victories were being hijacked. So a couple of examples here. Within this particular element, fetuses were given value, and I would just point out in this first quote, which could be considered offensive by some, the disregard for the considerations about how a pregnancy occurs, particularly for victims and survivors of sexual violence. And so this really underscores that the intention here is really to give priority to fetuses over and above people who may become pregnant. The 14th Amendment was the constitutional basis of the claim, and there was specific mention of this multiple times within the data. And fetuses, as we said, were compared to other groups experiencing discrimination, both those that have historically experienced discrimination, as well as those that continue to experience that discrimination today. The third element that we found, and again, these all build upon one another, is that states have the right and perhaps the obligation to provide legal protections over and above federal protections. So a concrete example outside of the field of sexual and reproductive health and rights would be the case of California, which has emission standards over and above federal protections. And so we might argue that that's a good thing, that the state has the ability to protect the health of its citizens. However, that same argumentation is being used here in the reverse, which is to say that the group of citizens, and I'm putting air quotes around citizens, that the state is trying to protect are, in this case, fetuses, and not necessarily people who are pregnant. So the argument here is that states have to rebalance power between themselves and the federal government by sort of claiming this, this obligation that they have. One of the weaknesses that was pointed out in the bill, and this, again, these are supporters of the bill that pointed these things out, was that there was not a fiscal note. And so there were real concerns, even among supporters of the bill, about the fiscal implications of this bill. And in particular, the Georgia bill included fetuses in utero as natural persons, which is a term that exists throughout the Georgia Code. And so there were really some wide sweeping implications of this language that went beyond just the particular concerns of this particular legislation. So this is a table that we include in our paper, and I just want to point to it really quickly, because what we try to do here is to point out the kind of appropriation that was used, and that was really the main strategy. And there are lots of things that are appropriated, mainly medical science, but not just obstetrics and gynecology, also things like pediatrics, as well as the law being appropriated. And we talk about the different tactics, the kinds of tactics that are used, for example, misinformation, misrepresentation, and co-optation. And then within this table, we give a specific example of the anti-abortion language that's used, and then we also fact check that language. So for example, in this first quote, you see mention of the American College of Obstetrics and Gynecology, which is a well-respected professional organization in the field, and then reference to their guidelines, which actually do not say anything about early abortion bans or this kind of legislation, but there's a connection being drawn between that credible organization and the claim that's made in the second part of this quote, which is the 95% likelihood of pregnancy after the detection of fetal cardiac activity. So we try to break down these quotes and then fact check each piece of them to actually point out the ways in which information is being conveyed in an inaccurate form. So we're really, really grateful to the journal for the opportunity to share this information, and we're really excited to be in conversation with the other panelists about this topic. Thanks so much.
Thank you very much.
Thank you, Dabney and Suba, for presenting those interesting findings. So Megan, I know that you work at a service provider and essentially do advocacy and lobbying and have been engaged from that perspective. So I'd love to hear some of your thoughts about how to engage and how you have engaged in this legislative process and what that looks like now. Megan, I think you're on mute. We want to hear what you're saying. Yeah.
Can you hear me now?
Great. Perfect. Yes.
Okay. And can you see the slides?
Yes, we can. It's great.
Great. Thank you. So, hey, y'all. My name is Megan Gordon-Kane. I work at Feminist Women's Health Center. We're an independent abortion provider in Atlanta, but we do a whole lot more than provide abortions. We do a lot of community outreach and engagement work, voter registration, civic engagement, community education, grassroots organizing, and I do all of our state policy work. So I am at the Capitol every day that our legislators are at the Capitol, including for the fight on HB 41. And so I want to start by providing a little context of what the rhetoric that Dabney and Suba discovered and like how that actually looked in practice and what the impact was of the debate around the bill and how we engaged with that, and then like what's been happening in the last 8 months or so since the governor signed this bill into law. So I was thinking a lot about how the proponents of 41 were speaking and who they were speaking to, because we found that as we were talking to legislators and trying to find out how they were going to vote on the bill and figuring out what the hangups were, that this was not about policy. This was pure politics. The overwhelming majority of our General Assembly already had their minds made up based on like whatever pre-existing beliefs about abortion they're bringing in, or about fear of their primary voters. For those of you who aren't in the US, just for context, the way our electoral system works is that folks will have a primary election first. So it would be, for example, Republicans running against other Republicans or Democrats running against other Democrats to figure out who goes on to run against a member of the other party to try to win the seat for their district. And most of the districts in the state of Georgia are drawn to be very safe for the incumbents, which are Republicans right now and have been for the last 15 to 20 years. So what that means is that the base of primary voters who tend to be the most hardcore in their beliefs are the people that elected officials have to worry about, because those are the people who can get them in or out of their seats. And Republican primary voters are incredibly anti-abortion. Like this is not a base that like abides any sort of flexibility on the issue. And so we heard from some folks that they didn't think this bill was a good idea, but they had to vote for it because they knew that their primary voters would demand it. One additional political factor was that there was a lot of pressure from the governor of the state. Governor Kemp was elected at the end of 2018, so last year was his first legislative session, and he campaigned on making sure Georgia had the strictest abortion laws in the country. And so this was very much a political priority for him. And I remain convinced that if it hadn't been, we would have been able to stop this bill. Yeah, it was very few people we found in our conversations were actually considering the merits of the argument or thinking about, you know, the 14th Amendment or what the medical science tells us about 6 weeks. Most folks were thinking about the politics of the situation, who they had to be accountable for, and what would happen if they voted either way on this bill. The few folks who might generally be anti-abortion, but were actually thinking through, what does this ban mean in practice and what is that going to mean for people? A lot of those were the folks that we were able to peel off largely. And so because of that, I am sort of forming the theory that the rhetoric was not for their colleagues, that Ed Setzer, the sponsor of the bill, was not as much speaking to other Republicans when he's like making these convoluted arguments about rights. He's talking to the public, and he's talking to eventually the courts. This is just my theory, because if your colleagues are all playing into the politics, then they're not the rhetoric isn't as relevant to them. And of course, as Dabney said, there were a lot of folks from the community who came to speak in favor of the bill, and those folks overwhelmingly leaned into the fetal viability argument, and those were all very emotional arguments. Overwhelmingly, they were either like, doctors told my mom to have an abortion and she didn't, and I'm glad to be alive, or when I was pregnant, my doctors told me to have an abortion and I didn't, and I love my child. And so that it was very, very emotion driven, very much like, look at this beautiful child to be loved. Do not murder this child. Please support this bill. And so the way we push back on that, and I have to say, this was not as thought out as it could have been. Like, we did sit down and think through our strategy, but Georgia was the first in the country to introduce one of these heartbeat bills that have since like swept the nation. And so this is what we did based on what we had at the time in the roughly 4 weeks that this went from introduction to being passed. It moved very, very quickly. And so I hope that other states or other advocates who might face something like this in the future can take and learn from what we did and maybe adapt and do better. I feel really good about what we did, but it's not as if we were sitting down and thinking, oh, they are making these legal and appropriative scientific arguments, so let us therefore do this. We were thinking more about who are the handful of Republicans we would need to peel off to win the vote and what was the most likely to be persuasive to them. And so because of that, we did not engage directly with the arguments Dabney and Suba described a whole lot, because we were focused more on getting our message out than responding to theirs. There were a few points where there was direct engagement, mostly around them trying to appropriate the 14th Amendment to the Constitution, because they literally skipped the first part of that amendment, which is people born or naturalized in the country then have these rights to equal protection that they were quoting. And so some of the lawyers on committees and the bills were like, hey, wait a second. This amendment that you're trying to cite in favor of your argument literally by definition only applies to people who are already born. And so there was a lot of back and forth on that. And then my very favorite moment from this debate, my second favorite. My first favorite was when a representative on the Health and Human Services Committee asked the sponsor of the bill how many times he had been pregnant. My second favorite is when basically a representative during the floor debate on the House floor called them out for their appropriation of scientific evidence and of sort of misuse of data because the House version of the bill, this was taken out from, eventually they took this out after this incident, but the version of the bill that was on the floor had a quote that said, "The American Academy of OBGYN's clinical management guidelines provides that ultrasonography that detects a heartbeat is the preferred modality to determine the presence of a viable intrauterine gestation." Like, this is exactly like Dabney described this argument exactly, and then Representative Jasmine Clark caught that there is no American Academy of OBGYNs. They're talking about the American College of OBGYNs, and they literally just changed the name to get away with misappropriating the data, I guess, so the College of OBGYNs wouldn't come after them. So she reads that quote, and then she just says, "That organization does not exist," and just like left. It was beautiful. And so those were the two most direct areas where we engaged with their arguments, because they were just too egregious to ignore. But most of the time we focused on facts about the implications of this bill, stories about people who really needed an abortion. And we really just owned the science and medicine. We simply refused to let them have that, which wasn't hard, because we had an enormous turnout from medical professionals who were advocating against the bill. Like, I'm talking like 20 plus doctors testifying in one of the committee hearings against the bill, and they had, I think they might have had one medical professional. And every single major medical group in the state came out against this bill by the end. And so because of all that, we didn't have to really engage with their counter arguments, because it was very, very clear from the turnout and the response that the science and medicine was on our side. And so we didn't feel a need to engage with their appropriation of science. Also, one of our main strategies for pushing back was just a sheer show of force. If this was all about the politics and we needed to prove that the people didn't want this, they would be scared to vote against it. And we had hundreds of people in the Capitol multiple days a week advocating against this bill. In the Senate committee hearing, we had so many people show up to oppose the bill that they filled the committee room, and the people who were there to testify in favor of the ban could not get into the room, and they had to wait in the hallway and go be called in to testify when it was their turn. So those were the main strategies that we used to fight the bill. And even though this was passed, I still feel like this was the right strategy to choose, because we only lost by 2 votes. And so in a state that has such strong conservative majorities, when the governor was putting so much of his personal political capital behind getting this passed, I think the fact that we got that close really shows the strength of this approach. Okay, so that was like 9 months ago. What have we been doing since then? And what has been happening since then? After the governor signed the bill, there was a flurry of press coverage, some of which I found frankly irresponsible. Headlines like "Abortion is now illegal in Georgia," when the bill as it was written did not go into effect until January of this year. So would have gone into effect 2 weeks ago if a court had not stopped it. And so we had a flurry of patients calling to make sure that their appointments were still happening. A lot of people who were very confused. And so we at Feminist and advocates across the state, we did a ton of interviews. We set up a microsite called "Abortion is Still Legal in Georgia." We just did everything that we could to get out the message that abortion is still legal in Georgia. And we hope it's been effective. We can't, when people call, we can tell them, "No, your appointment is still on, don't worry." We do worry about if there was anyone who just read that article and didn't bother to call and check and just assume that abortion is now out of reach for them. So we're still working on getting the word out to make sure that people understand that abortion is still legal. we are also, along with many other organizations in the state, we are suing the state to argue that this is unconstitutional and should never ever go into effect. Right now, the judge has said that while we continue to argue about whether it is constitutional, it cannot go into effect. And I know I'm gonna pass it on now, I guess, so we can hear more about the lawsuit from the legal organization at the table. Thanks, y'all.
Thank you so much, Megan. So that was a really deep dive into a case study looking at what's been happening in the US state of Georgia. So Nimra, I know that a lot of your work and a lot of the focus from the legal perspective has been tracking these trends across the United States. So I was wondering if you could tell us a bit more about that. What are you seeing? Are these trends coming up more and more? It'd be great to hear more from you. Nimra, you might be muted. We can see your slides, but we can't hear you.
Hi there, can you hear me now?
Great.
Awesome, thank you so much. So I'm gonna move my slide along. Cool. Thank you for the introduction. My name is Nimra Chowdhry. I'm State Legislative Counsel here with the Center for Reproductive Rights. We are a global nonprofit dedicated to advancing reproductive health and rights as fundamental human rights. So the objective of my presentation today is, again, to give an overview of early abortion bans in the states across the United States, and then provide some legal context around the challenge against Georgia's 6-week ban. So you've heard the term heartbeat ban earlier in the presentation. We frame it as 6-week. Generally, that's the point in the pregnancy that these pieces of legislation are talking about. So just to kind of clarify that point for us. So restrictions, I wanted to give you a little bit of overview of what's been going on in the country since 2011. So since 2011, over 400 restrictive abortion bills have become law across the country. In 2019 alone, we saw 18 states enact 46 restrictions that restrict abortion access. Early abortion gestational bans were a very big focus of the 2019 legislative session, and Georgia was one of the 9 states that passed bans in 2019. So these types of bans include a complete abortion ban that happened in Alabama. We saw 5 6-week bans. Georgia was one of them. 1 8-week ban out of Missouri, 2 18-week bans out of Arkansas, and in Utah. So I have a little asterisk here, and I'm going to emphasize this throughout the presentation, but none of these early gestational bans are in effect. So more and more states are introducing and enacting 6-week bans across the country. However, I wanted to highlight that, we've been seeing these types of bans pop up since 2011 when we started tracking them, starting out in Arkansas and also in Ohio. They were introduced in those 2 states in 2011, but they were not enacted. And then 6-week bans have been introduced in about 25 states since then and enacted in 7 states. So important to note, again, that every federal court considering laws prohibiting abortion before viability on the merits, and we'll talk a little bit more about this later, has ruled that it violates the 14th Amendment of the United States Constitution. And this means that any bans similar to Georgia's law that have become law in the United States are currently not in effect. So here's like a timeline of what I'm talking about. So we saw 2 states introduce this type of legislation in 2011, none were enacted. In 2012, we saw 4 states introduce this type of legislation. Again, none were enacted. In 2013, we saw 8 states introduce this type of legislation, and that was really ramping up what was happening across the country around these types of bans as new restrictions. 2 did end up becoming law, in Arkansas and North Dakota. Arkansas was the first state to enact the 6-week ban, and shortly thereafter it was North Dakota. Both of these laws were struck down by the courts as unconstitutional, and we've been monitoring this type of policy since then. After that, from 2014 to 2017, there was a halt. Considering the litigation and what had come out of the courts, states were still focused on these types of bans, but they were not getting enacted. This all shifted in 2018 when eight states introduced the bill and 1 became law in Iowa. Iowa became the 3rd state to enact this type of restriction. 2015 was a huge year following early gestational bans. We saw a huge shift in the political landscape, of other folks have talked about in the presentation, and we saw 5 bills become law, and one of them was Georgia's restriction. 2020 so far, we have 7 states that have 6-week bans pending. We're very early in the state legislative session, so we can only predict how many more we'll see come down the pike, but this is something that's very, it's a trend we're going to see continue, and it's coming from the 2019 legislative session as well. So this next slide shows you the most extreme gestational bans in the state. As many states have multiple gestation bans, you can see that roughly more than half the states have pre-viability bans. And then there's another 15 states that have that ban abortion at the point of viability. As talking about again, none of the pre-viability bans are in effect, and they're all enjoined by litigation so far. So this takes me to what's going on in the litigation in Georgia in the case Sister Song Women v. Kemp. The center, along with our partners, are committed to continuing to ensure that bans like the one in Georgia do not go into effect and are defeated in the courts if they are enacted. So we're working at the legislative level, of course, pushing back against restrictions once they get introduced at the legislatures. As we've talked about, lots of bills get introduced, a lot of them don't get enacted. So that's obviously a part of something that we consider a part of our strategy. But on the flip side, if they do get enacted, what happens is that we will challenge these types of laws. So in this case, specifically, the American Civil Liberties Union, along with the Center for Reproductive Rights and Planned Parenthood, brought a challenge against House Bill 481, Georgia's 6-week ban, in June of 2019. That law was slated to go into effect January 1, so earlier this year, but what was then blocked by the courts in October of 2019. So plaintiffs include Sister Song, Women of Color, Reproductive Justice Collective, Feminist Women's Health Center, Planned Parenthood Southeast, Atlanta Women's Medical Center, and other providers in the state. So when filing lawsuits such as this, we consider the impact of abortion restrictions. In particular, we challenge and plan to challenge laws that aim to completely ban or limit access to abortion care in states. We also look at the effects these laws have on the most impacted communities. So in filing this challenge, for instance, we looked at how this law attacks low-income people, Georgians of color, and rural people the most. And in fact, Georgia faces a huge and a critical shortage of reproductive health care providers, and the state faces huge hurdles when it comes to Black maternal health and infant mortality, and this was all part of the challenge that was brought against the state. So just a legal framework a little bit, this is a case under the United States Constitution, so it's a constitutional challenge. The U.S. Supreme Court has affirmed time and time again, starting from Roe v. Wade to the most recent case in Women's Health v. Hellerstedt, that states cannot ban abortion prior to viability. Roe v. Wade was a landmark decision which made abortion legal in every state in the United States, and it defines it defines viability at the point at which a pregnancy can survive outside of the uterus, with or without assistance. So pre-viability bans, such as the one that we're talking about today, have been struck down each time by federal courts because they are directly contrary to this holding of Roe. This is why previous bans were struck down, and this is why Georgia's ban is currently blocked from enforcement today. So with the 6-week ban in Georgia, it's currently under a temporary injunction, which prevents the law from going into effect until a full case can be heard on the validity of the law, which is forthcoming. So our teams, as the organizations I mentioned earlier, are currently in the discovery phase of the case. So there's going to be a lot more coming down about that litigation, but of course, the law is currently not in effect. The last thing I will say is that litigation is very expensive for states and costs taxpayers tons of money. The center, along with our partner organizations, folks on the ground that are working against these bills constantly, are committed to protecting access to reproductive health, and we will continue doing so throughout the next year and years to come. So I hope this kind of gives you a little bit of an overview of what's happening in the legislative realm and a little bit more about the litigation. And I'll stop right there, and I'll be happy to answer any questions at the end. Thank you.
Thank you so much, Nimra. So as we know, who've worked in reproductive health and rights over the years, trends in these fields from the US can and have gone global. So Gina, a lot of your work has focused on global access to safe abortion. So could you give us a bit more of the global perspective on what you're seeing?
Yes, hello, can you hear me?
Yes, loud and clear.
Great. All right. Good morning, everyone. Good afternoon. My name is Gina Dillon, and as Nina said, I'll be talking to you today about the global perspective that we have at IPAS. You will hear lots of differences between the experience globally and what we've just heard, but I think you'll also hear some similarities that hopefully might help you think through the challenges in your context. At IPAS, we work to ensure that people can access the abortion care they need wherever they need it. The way we do our work brings us to the health sector, to the communities, and to the systems and institutions that are responsible for providing healthcare in a particular country. This slide is to give you a sense of where we work. In most of these countries, abortion is legally restricted except in very limited circumstances. I wanted to start just by doing a quick reframing to help us situate abortion advocacy for the global context. We've been talking here about the right to abortion under US law. The US is complex and dynamic, as we've heard, so we know it's not as simple as this, that there is a right that allows abortion for any reason. But because we're focusing on early abortion bans, it's very clear from the global perspective that we're talking about when the abortion right has been almost completely eroded in the law, making it more a crime than it is a right. We're, in early abortion bans saying essentially that at the earliest point in time when you could discover you're pregnant, just a little bit past that point in time, abortion is now a crime. From the global perspective, that sounds very much like, the very last thing you can do just short of fully criminalizing abortion, as we're hearing. And that's really where we tend to live as IPAS and other global NGOs working on this topic. We're working in settings where it's not necessarily a conversation about gestational age limits. Instead, we're really talking about working from a place of abortion is already mostly a crime, and where do we go from there? And that's really the perspective that I'm going to be sharing in my presentation. And just a short pause here to say that, when we see abortion criminalized, there are often limited exceptions for circumstances where it's considered appropriate to seek an abortion. And as you all know, from the US context as well and others, those exceptions tend to be woefully underused, and in most cases people aren't aware that they even exist. So from our perspective, and using a very oversimplified graphic, depending on where you are in this gap between abortion being treated as a right versus it being treated as a crime, and what's happening in the middle to limit access, our advocacy positioning and approach really has to orient itself to match. So that means kind of looking at which direction we're going. What we've been talking about here is kind of moving backwards where there is an established right, and we're fighting and trying to eliminate barriers and fight the attempts to roll back that right. At IPAS, for our positioning, we're really coming from a place, like I said, abortion long being understood as mostly, if not always, a crime. And we're often trying to move from that restrictive place to progressively realize the right to abortion. And I really have to emphasize the word progressive here, because for us, progress is slow and the change is incremental. For us, it's because the idea of abortion as a crime is so firmly and deeply entrenched in the local context. The idea that it's a right is actually new, or just not so firm in many of the places where we're working. And the approach at IPAS, given that, is that we try as best we can to design country programs that address abortion from the different perspectives that we believe matter the most. And that's why we work across the health sector, with communities, and with policymakers and institutions. So because our existence has been always rooted in a relatively hostile setting for abortion, we know what this picture can look like. This is just a snapshot, global perspective on what some of the norms look like when you find yourself in a restrictive setting. And we're looking across the policy, health sector, and the community norms that I mentioned earlier. And it's likely that here in the US, some but not all of these may be familiar to you, depending on where you live and where you work. And what this all really boils down to for the individual that is pregnant and needs to not be pregnant, there's often nobody to turn to for help. And so what happens then? I think we could all answer this, because even though the US is unique in many ways, but in answering this question, we're all sort of same, because no matter where we are in the world, if you have nobody to turn to and you need an abortion, you're likely going to try to find help or help yourself. When the system doesn't give an answer, people find solutions. That's kind of what we do. And fortunately, with the rapid transformation of how people share information and the advancement of abortion technologies, it's becoming easier and safer for people to help themselves in ways that don't actually put their lives and their bodies at risk. But that has not always been the case. And it is still the case that in many places, people who are seeking an informal abortion often end up with disastrous consequences to their health. So that was sort of the global context setting, but I wanted to really bring our perspective to life a little bit by also sharing a country case study. It's not a rigorous quantitative review of our programming by any means. It's just a story about our experience working in Malawi. So in Malawi, abortion is only permitted to save a pregnant woman's life. After some initial assessments and conversations with local partners and the community-based stakeholders that we came into contact with, we realized that local partners had an interest in this issue. They cared about this as a public health concern, as a human rights concern. The maternal mortality data in Malawi is compelling, particularly on unsafe abortion, and it disproportionately impacts young women and women in rural areas. We also saw government officials expressing interest to talk to us. They wanted to know what kind of solutions could we come up with together. And so that's really how it started. I can describe our work across the two key approaches that we took, the first being with the local partners. So in doing this is where we were really seeking to mobilize the interest that we were hearing from in the communities. And we really just wanted to support wherever that energy could go. So with the community-based organizations and other interested groups and individuals, we convened and helped launch a coalition of organizations. The role of IPAS was really just to provide operational and technical support. The advocacy agenda that was set by these groups was focused on reforming the restrictive law and sort of really broad-based stigma reduction around abortion. So specifically, we helped to convene the groups. We provided resources so they could conduct their advocacy and their activities, providing strategic collaboration to move us closer. And the pictures that you see here are from an album release party where about 10 Malawi artists came together. They wrote and recorded songs about problems of unsafe abortion, the need for reform, the need for a rights-based approach. Thousands of people came out. The Malawi Ministry of Health was invited and did attend, and that really gave a legitimacy and a credibility to the work. And now what this work looks like is really helping the coalition become more effective in sustaining itself, perhaps serving as a regional model so that other groups in other settings can apply the same tactic, which can work no matter where you are, because this is a global truth that I would like to offer, and that is anytime you're in a restrictive or hostile abortion access setting and you want to be speaking up for change, and if this is not your usual topic of conversation, the ability to stand shoulder to shoulder with your community, with your partners, and to have a collective voice can really make or break your efforts. And I think we kind of heard that very clearly from Megan's sharing as well. And the assumption that we're making about this work is that communities can influence policymakers. And also we're saying that policymakers must hear from the communities that they represent, especially when it's a controversial topic. But I will say that our work with communities is challenging. The thing about coalitions is that they can be incredibly powerful and effective in amplifying a collective grassroots voice, but they can also be expensive and very hard to manage. At the end of the day, it boils down to we are organizing diverse groups on a controversial topic. In most cases, we're asking them to do this for free. So it's hard. There's almost always more work that we could be doing, but we know it's essential to really have change. And so that's why we do it. It brings me to the other side of our approach. I mentioned that the government was also interested in addressing abortion as a public health concern in Malawi. They weren't necessarily saying they wanted to decriminalize it, but they were interested in talking. And so we went with them. We worked with government because they expressed this interest. And what we found, another global truth about abortion advocacy is that when you're working with government officials and politicians, outside pressure can also help. If you have internal pressure from the grassroots, combined combining that with external pressure is also effective. So the approach that we've taken is using international and regional human rights systems and platforms to put pressure on government, because we're assuming here that when you put someone on a regional or a global stage and you make them answer to the human rights aspects of abortion in their jurisdiction, you can actually hustle in those spaces and create openings where you have some leaders who are interested and curious about how they could actually do better. And when you have that political capital, especially from those who are closest to their constituencies, it's incredibly valuable. And I think we heard that in some of the earlier remarks as well. And it's been really powerful in Malawi. The approach has been to use these human rights stages, even I think as we were hearing, even if the human rights stages in the US aren't formal, politicians are talking to the public. And so is there a counter narrative that we can offer that's rights-based? And when we do this work, we do it by helping the government know what it can expect to hear, where it's likely falling short on these obligations. And then we also are trying to help them view us and civil society in general as a trusted partner to help them address the shortcomings that they're being called out for. And because of this work, we have a lot of things. We have a draft bill that's ready to be considered by Parliament that expands the grounds for abortion. Abortion is also recognized in government, national, subnational planning documents. And Malawi is a small country. This is in some ways a small and big example. I could talk for days about all of the details of this programming, but mostly I just hope it's been useful in demonstrating that there are some aspects of abortion advocacy that are universal in our shared experience. And before closing, I just wanted to point and direct you to a few more of the resources that we've developed that help us as we try to move away from abortion as a crime and more towards the right of it. We've tried to expose the reality of criminalizing abortion by researching and publishing the lived experiences of people who have been arrested or detained for abortion-related offenses. Those make for incredibly powerful advocacy tools. We've also sought to partner with and provide technical support as needed across the legal sector. So for us, that means working with lawyers, working with judges and police officers. These are professionals who are not necessarily always trained to respond to abortion issues, but who do become key players, especially when abortion is criminalized. So I will stop there and pass it back to you, Nina.
Thank you, Gina. That was a great presentation. And I love the fact that, you know, two of the key lessons that you highlighted, especially in the Malawi case study on community mobilization, on external pressure and influence, very much seem to also echo the information that we've heard from Dabney, from Megan, from Nimra on how these things are playing out within the US context as well. So, you know, while these lovely ladies have been speaking and presenting on various aspects of early abortion bans, we've been fielding your questions from the participants. So I have a couple of questions, and I'll start with ones directed at Dabney, Suba, and Megan, actually, because they involve the legislation and the bill in Georgia, or I guess the law that now has an injunction. So one of our participants asked, they were surprised to hear about the misinformation and misinterpretation on technical medical issues. So what, if any, is there a vetting process? Like, what does that look like in terms of the technical and medical aspects of these bills that has now become a law in Georgia?
So thanks very much for that question. I really appreciate it. And as a researcher and as a scientist, I just want to underscore, not because I think my field is so important, but I do want to underscore the importance of science and the importance of rigor. So what I'd like to point out is that part of what we think is important about our study is that it's the first of its kind study looking at these kind of early abortion bans. And we used a lot of rigor in our methods, which is to say that we didn't just take anecdotal evidence from what we heard people say during session, but what we did was we actually took all of the committee hearings, we transcribed them verbatim and coded them using qualitative methods, so that the information that we have really gives us a leg to stand on. So I actually think that the importance of medical evidence and scientific evidence and its misuse is really important. And part of the reason for this study was to clarify exactly the way that that's being done. So I really, really appreciate that question. Of course, our study does have limitations, and those limitations include the fact that we are only looking at one case, which was the state of Georgia, and also focusing, I think, to what Megan spoke about. Her perspective is sharing that of opponents to the bill, and our study was only looking at supporters of the bill. So we do recognize that limitation. And we also agree that the important role of clinicians and providers have in talking about the science and talking about the evidence. And I think that Megan can speak more to the way in which that was done from the opponents to the bill. But with regard to the inclusion of misinformation within the debate and within the law or the bill itself, what I would point to is that these early abortion bans are continuing as state legislatures open across the country. And for example, there's very similar legislation right now in South Carolina, which actually puts into the bill some of the exact same misinformation that was used in the argumentation in Georgia. So the question has to do with how that information has to be vetted. And I think that this underscores the important role of participatory democracy, because these lawmakers are not subject matter experts in abortion or sexual and reproductive health and rights. And so this really underscores the importance of activists and advocates and scientists and researchers in making sure that the information that's included in this kind of legislation is accurate.
I would add that the supporters' goals were to even respond to the climate that we currently have, which is a climate of belief in evidence-based medicine and the need for evidence to prove your point, essentially. So the inclusion of these medical misinformation or the inappropriate use of professional organizational names was a way of lending credibility to an otherwise untenable argument. And I would also add that the 14th Amendment protection argument is unique in the sense that they're continuing to co-opt an argument that pro-choice advocates have used for a very long time to protect women's rights. And they're also, in the context of the state, trying to redefine the point of viability and undermine Roe v. Wade, and so they're doing that by co-opting our science, which we have used successfully on our side for many, many years to discuss how abortion bans hurt women, and particularly women, families, and women of color.
I just want to add that, one would think that there's going to be some process built into making laws where someone is going to check and say, no, there is no evidence to support this. You can't bring this legislation. That does not exist. They can introduce whatever bills they want. They can make whatever arguments for it they want. There are zero safeguards, which is mind-blowing. And I think that just makes what Dabney said about participatory democracy all the more important, because many people disagree with me, but I'm inclined to believe that there's more ignorance than malice in our state governments. And so I think that having people who understand the science and the facts to come and point out to our elected officials that, like, what you are trying to do here does not make any sense is really, really important.
Great, thank you for those responses. And I'm conscious of the fact that we're technically 1 minute over time. So thank you for the attendees who have stayed a little bit longer. I do wanna ask one last question, and this is for all of the panelists. And, I think for me, listening to all of the information that was just shared, I'm curious, and I know that this was one of the questions as well, how has the legislation or restrictive abortion laws in general globally, how has it really affected the availability and accessibility of services and enhanced or focused on the inequalities that are documented in relation to women of color and in relation to women who live in rural areas? It'd be great to hear a bit more quickly from the panelists about what that looks like and how that's impacted both domestically in the US, but also globally.
I'll start us off. So, of course, the law is not currently in effect. So it has not people are afraid, some people are uncertain about whether abortion is legal, but for the most part, as far as we can tell, it has not made super significant changes to abortion access in Georgia. That said, abortion access in Georgia really sucks. There are about 13 abortion providers in the state. This is a pretty large state, and most of them are in the metro Atlanta area, which can be as far as a 4-hour drive for other folks in the state. And we have a lot of laws banning insurance coverage for abortion. And so if your insurance doesn't cover abortion, if you live very far away from a clinic, if you make the state minimum wage, which is $5.15 an hour, which is nothing, it's going to be very, very difficult for you to get to an abortion provider to begin with. So these are already problems that we're facing. And if this law goes into effect, it's going to make it even worse. And I think, if that were to go into effect, I think you'd see a lot of advocates on the ground shifting our efforts to funding folks in getting to other states.
Yeah, and I can add to that. So I think from our perspective, generally speaking, we'll look at how many people of reproductive age there are in the state and just look at and see how many providers there are for healthcare for them specifically. And, the numbers are shocking. Restrictions not only around abortion care, but restrictions around reproductive health care generally, insurance restrictions for low-income people. I mean, there's so many number of indicators and factors that we look at that prevent people from being able to have access to healthcare. And with restrictions like this, it just compounds all those factors. We also look at benchmarks such as maternal health, child healthcare, and welfare. All of these taken together show us a bigger picture of what the impact of this type of legislation is. Additionally, we'll see what's happening in other states that have gone down a similar route, right? We have a comparison where we can look at a political makeup or a makeup of a state depending on how many people live there and how much access to healthcare there is, and build that comparison. In Texas, there's a lot of quantitative, qualitative research done after a slew of restrictions happened in the middle of the decade last year. I can say that now, I guess. So all of that taken together kind of paints a larger picture for us when we're bringing challenges and also pushing back on legislation. And we can actually show that, in fact, what is happening in those states.
And I could maybe just add to that from the global perspective. I think it's a little, again, the reframing is really helpful, because in a lot of the context where we're working the law, like I said, we're sort of starting from the assumption that this is a crime. And if we are really even looking at that, that doesn't mean all abortions should be prohibited. But if we look at the health system and the access to safe abortion care or post-abortion care for complications, those systems aren't working. So we're also seeing that there are sort of broader health system challenges that are specific to abortion in some cases, but in some cases are just reflective of the broader health system infrastructure. To the extent that it is abortion specific, our approach really has to look at the entrenched stigma and hesitation to talk openly about abortion across different stakeholders. I think there's also, as was said earlier, sort of at the very local level, less respect for women's empowerment and autonomy and bodily integrity in making these decisions for themselves. And really, we have to focus on sort of opening up dialogue around those topics if we really want to, from the bottom up, make a systems change. And that's really how our approach looks at this.
Thank you so much to all of the panelists. At this point, we've gotten a lot of questions, so thank you so much for all of the questions that have been sent in. Given the time, we did go a little bit over, which I think was helpful to hear from the various panelists, also from the global perspective. But I just want to remind the participants as well that if they are interested in finding out more information on either the work of the panelists or are interested in the general work of SRHM, to please also go to the SRHM website and follow us on Twitter.